We have one counsel, and we have one more to go. We have both counsel. Good. We are then ready to go. Attorney Gunn, my understanding is you are here on behalf of the appellant this morning, so I will proffer the question to you. How much time would you like to reserve for rebuttal?
Thank you, Your Honor. We'd like to reserve 5 minutes for rebuttal, please.
Seeing that we're having all types of some interesting electrical issues today, you please bear with us, but the good news is the clock is running on a battery. So hopefully I'll have no problem with the clock. Everything else I cannot speak to in terms of electronics.
That is okay. Great.
With that, counsel, you may begin.
May it please the court. My name is Tracy Gunn. I represent the appellants, Burrick Incorporated and John Burrick individually. We are appealing a final judgment in favor of the estate of George Gage in this wrongful death case arising out of a motor vehicle accident, and we have raised 4 issues on appeal. First, whether the trial court erred in disregarding the jury's apportionment of fault. Second, whether the Burrick defendants are entitled to a set-off in the amount paid by settling co-defendants. Third, the remediator. And fourth, the agency vicarious liability claim against John Burrick individually. Beginning with the apportionment issue, it's pretty straightforward, Your Honors. The plaintiff alleged and went to trial on theories of both direct negligence and vicarious liability against both Burrick defendants. The plaintiff agreed that the jury should apportion active fault among the 3 defendants, the driver, Burrick Incorporated, and John Burrick individually. This allowed the plaintiff to make the Burrick defendants' active fault a theme of the case. And then after the verdict, the plaintiff changed course and argued for the first time that under Groman versus Posey, the 4th District's decision, that the Burrick defendants' direct negligence was actually derivative liability and not active liability, should be treated as vicarious liability and should not be subject to apportionment. So the plaintiff convinced the trial court to keep the large damages award, but to disregard the jury's apportionment of fault. And it's our position that this ruling was erroneous, essentially for 2 categories of reasons. First, the apportionment of fault statute mandates that the court shall enter judgment against each party on the basis of that party's percentage of fault. And the statute on its face applies to negligence claims. We've cited for the court in the brief 25 years worth of cases applying apportionment of fault to negligent entrustment of a motor vehicle claims because they are, again, negligence cases. They're based on active negligence. It's not pure vicarious liability, and there is a requirement of some fault on the part of the entrusting defendant. I don't think there's really any dispute about that. What happened in this case is that the trial court accepted the plaintiff's argument to expand the 4th District's decision in Groman versus Posey to recharacterize this negligent entrustment liability from active negligence that's on the verdict form to derivative liability, to deem it equivalent to vicarious liability and not subject to apportionment of fault. One pretty obvious reason why we claim that the Groman case does not apply here is that it was not a motor vehicle case. It was a negligent credentialing case. And Groman, the 4th DCA's decision, should not undo this 25 years of case law holding that negligent entrustment of a motor vehicle is an active negligence claim subject to apportionment of fault. And then second, the whole idea behind Groman, the reasoning behind Groman, was the court's finding that because the subsequent tort is foreseeable, it would be unfair to allow the foreseeable conduct of the active or immediate tortfeasor to reduce the responsibility based on the very harm that the derivative defendant was supposed to prevent. Well, the Florida Supreme Court in the YH Investments versus Godellis case rejected this analysis. That was the case about the railing and the parent's supervision. And just like the negligent entrustment in this case, the parent's negligent supervision in Godellis was the thing that created the opportunity for the direct or active tortfeasor to harm the plaintiff. But the Florida Supreme Court said, yes, you can put that mother's negligence on the verdict form because it's active and it's negligence. And the important kind of part of Godellis was that it rejected the entire basis for the holding in Groman. and said that putting the negligent supervision by the parent on the verdict form is not a reduction. It's just applying what the statute says, which is this is a negligence case. The defendant should pay their percentage of fault. So our first point is that Grobman should not have been expanded to include and to change the law on negligent entrustment of a motor vehicle. Secondly, and alternatively, even if this court were to agree with that expansion of Grobman to deem this derivative liability not subject to apportionment of fault, this is not the case, it's our position, to allow the plaintiffs to take advantage of that change in the law because of the way the case was tried. Unlike Grobman, the allegedly derivatively liable parties in this case were on the verdict form. In Grobman, they were not. That was the whole issue in Grobman. Here, the plaintiff agreed to have them on the verdict form, did not object, agreed to the apportionment, agreed to the verdict form, agreed to jury instructions, suggested a 1/3 each apportionment, and then after the verdict said, oh, it's not really an apportionment case. This is just derivative and we should throw out the apportionment. So it's our position that the court should reverse the refusal to apply the jury's apportionment really for one of two reasons, either of which would be sufficient. One, that apportionment still applies to negligent entrustment cases and Grobman doesn't change that. And two, that the plaintiff's strategy decisions at trial in this particular case mean that plaintiff cannot benefit from any sort of expansion of Grobman.
And if I may, Ms. Gunn, how do you respond to the other side's comment that in this case they pled both theories?
Yes.
Because they pled both theories, they have the right to proceed. So regardless of what they agreed in the verdict form, regardless of that, they've never abandoned the other theory.
Right. And Your Honor, I think it's important to think about the fact that there's two types of liability here. And the plaintiffs characterized this negligent entrustment liability as additional and said they could recover under both. So we have pure vicarious and we have active negligent entrustment claims. What the trial court did and what the plaintiff convinced the trial court to do was not to say, well, it's all vicarious, so we're going to ignore this apportionment. What they did is they said, well, the apportionment is also vicarious because it's derivative. So they changed the character of the apportionment.
How does that affect the judgment at all if they are proceeding on the dangerous instrumentality doctrine, and by that relationship, they're vicariously liable for all the damages that the tortfeasor did? Right. There's still only, one set of damages? So even if we grant you relief, does it affect any award of damage?
It does, Your Honor, because—
Okay, help me out there.
Yes, and the answer is different as to the two Burrick defendants. As to Burrick Inc., the theory of vicarious liability was actually agency. I don't think that the record reflects that the plaintiff went to judgment on the dangerous instrumentality theory, but on an agency theory. So if apportionment applies, Burrick Inc. is going to be responsible for its own negligence of 30%, plus it's going to be vicariously responsible for the negligence of the active tortfeasor, which if apportionment applies, is not 100%, it's 40%, right? So, and then whether Burrick Inc. is also responsible for John Burrick individually, I think we all assumed throughout the case that that was the situation, and that you're right, the end result at the end of the day would be Burrick Inc. is 100%. That sort of relates a little bit to the issue number 4 on vicarious liability of John individually, because the plaintiffs are now claiming that he was not acting in the course and scope of his employment for the company. But all that to say, but as to John individually, it would make a huge difference because he would be responsible either for his own 30% plus 40% vicarious liability for the driver, or if this court were to agree with us also on issue number 4, his individual vicarious liability, he would be responsible only for 30%. So it would make a difference in that sense. And then the corollary to that, the corollary to apportionment, of course, is set off. We know in Florida law that the when apportionment of fault came into existence, the set-off statutes were already here. And the Florida Supreme Court gave us that trilogy of cases explaining how they're going to work together. And it's kind of a yin and yang, right? That the set-off statutes presume and presuppose and depend on the existence of joint and several liability. So if apportionment applies, you don't get a set-off. But if you're paying more than your percentage of fault, you do get the set-off. And
if I may, Ms. Gunn, but in this case, my understanding is that this case all dealt with non-economic damages. And help me out, non-economic damages are not entitled to a set-off. That's based on the case law. So what difference does it make in this case if we're dealing with non-economic damages, not entitled to a set-off? Where's the harm?
Your Honor, I think it has to do with the version of the statute that's in effect, because at the time that the two cases dealing with set-off, which is D'Angelo and Gowdy, were decided, the statute made a distinction between economic and non-economic damages in terms of who had joint and several liability. But the law still is, it all depends on whether you have joint and several liability. It all depends on whether you're paying more than your percentage of fault. So if these damages, whether they're under this version of the statute, whether they're economic or non-economic, if these defendants are paying greater than their percentage of fault, they should be entitled to a set-off. That's the entire basis for it. And so our position would be, because that it was inconsistent, really, that there might be a scenario under which we get only the apportionment. There might be a scenario under which we get only the set-off. There might be a scenario under which we get both, but there shouldn't be a scenario under which we get neither, is our position. And you know, I think the answer to your question about the difference between economic and non-economic damages just has to do with the version of the statute that was in effect at the time the D'Angelo case was decided. But the underpinning for those cases that talked about the continued right to set off in Wells and Gowdy and D'Angelo is that if you're paying more than your percentage share of fault, you should get a set off. And if that's what's happening here, either because of the character of the damages or because of the lack of apportionment, because they've been deemed to be derivative, that you should get the set off in that situation. The plaintiffs did really not contest.
And you know what, Ms. Gunn, I had one other question, if I may. How does the claim for punitive damage weigh in terms of, did the plaintiff have to list them separately to get actionable? Punitive damages, you cannot do it vicarious. You cannot do it. You have to be able to specifically assign fault. So I'm thinking, could that have been a basis why they had to list individually the folks on the verdict form in order for the punitive damages to stick? Sure. And with that, I'm just trying to think it through. And given their theory of liability, that, okay, then you have vicarious, you have alternative theories, they have to proceed that way. They have to list them in order for the punitives. Doesn't that weigh in terms of our view of how this whole case is being decided?
Sure, absolutely. And that doesn't really change our position, though, Your Honor, because the fact is this was tried as an active negligence apportionment case with also vicarious liability claims. And the reason that the plaintiff did that, whether it was strategically so that they could get a punitive damages entitlement, whether it was because that let them talk for the entirety of the trial about how Burrick Inc. and John Burrick should have known and had active fault in entrusting this vehicle to this person. Whatever the reason was, it was a decision that they made. This is not a case where the plaintiffs objected to the apportionment being on the verdict form. And then after the fact, on appeal are saying, okay, well, the damages are what the damages are, but the jury should never have made the apportionment. The plaintiffs agreed to the apportionment. Strategically, yes, they brought the active fault claim probably in part because that created the entitlement to punitive damages. But that doesn't mean they shouldn't be stuck with the other consequence of that, which is it's an active fault case. And negligent entrustment has always been subject to apportionment. and that this court should not allow Groban to change that. But at a minimum, when you try a case and you go in and you tell the jury it's a third, this is an active fault case, here's all our evidence of the active fault, you should be stuck with that when the time comes to enter the judgment. The plaintiff's argument on the set-off issue really was pretty narrow. Their argument, which the trial court accepted, was, yes, you should get a set-off in this situation normally, but we're going to argue an exception that applies here because John Burek got on the stand and said the franchisor defendants who settled didn't do anything wrong. And the issue is the trial court ruled that brought this case closer to Gowdy, where the verdict did not find fault. The difference between a finding of no fault and no finding of fault on the verdict form.
But if I may, Ms. because if you look at the transcript,
yeah,
he was very clear, and I guess maybe a strategy on the family business, trying to dissociate himself with the big bad maybe the big bad pinch and penny corporation, and then said, I didn't have anything to deal with them. This was all me. I'm the one that makes a decision. So I guess their argument is he can't have it both ways. He can't say, oh, I had nothing to do with them, because hoping to appeal to the jury, saying, hey, he's just a poor, young little entrepreneur versus, but then how do you reconcile that? Isn't that kind of like,
Counsel, as you answer that, I would remind you that we're past 15.
Okay.
I'm going to give the full 5. I just want to make sure that we don't have a long, extended 20-minute answer.
Okay, thank you.
Thank you, Your Honor.
We've had a long day today.
We have. I appreciate the opportunity to answer that question. And I would just direct the course of the difference between the Gowdy case and the D'Angelo case. And what the D'Angelo case said in the Florida Supreme Court in D'Angelo is that the Gowdy exception applies only where there's an express finding of no liability, a 0%. They're on the verdict form and they're 0%. We know that a set-off is applied by the court after the trial. It's not something that has to be proved at trial. My client didn't have to prove the fault of the franchisor defendants. The fact that he came in and said they're not at fault, that doesn't matter. The only thing that would matter is if the franchisor defendants were on the verdict form and 0% was applied to them. That's under Gowdy and D'Angelo and the difference between those two cases. For the rest of the issues, I'll just, I guess, rely on the briefs and reserve the rest of my time.
Thank you.
Thank you.
Attorney Tanaka, just so you know, so I can make sure I'm balancing all the time, you will have 21.5 if you need all of it.
Thank you, Your Honor.
You may begin.
Thank you. May it please the court. Lisa Tanaka for the estate of George Gage, the appellee. This is a post-trial appeal in which the estate is asking this court to simply affirm the final judgment. Now, there are multiple issues raised in this appeal, but before I jump into those, I want to highlight a common theme throughout. One which, notwithstanding the merits of the issues, provides this court a basis to affirm. And that is the appellant's error in consistently failing to act at trial and failing to preserve the issues for this court's review. Now, this appeal stems from a trial that ran very smooth. The trial lawyers, Benny Lazera, Joseph Figueroa, Michael Beck, were very careful in trying this case. And that's evident by the fact that there was very little contention and very few objections through the course of the 6-day trial. The parties agreed that the issues that would be tried. They agreed to the jury instructions, to the evidence, and to most of the witnesses. But now on appeal, the appellants assert that the trial court made numerous errors, yet most of those were not properly objected to, raised, argued, or preserved. In fact, the appellants admit they failed to timely act in their motion for remittitor. And as conditional motions for new trial based on longstanding Florida law, the time to file the motion for remittitor could not have been extended. So by the time the motion was filed, the trial court had lost jurisdiction to even consider the same. The trial court nonetheless properly denied the motion, and we'd ask that this court affirm the same. But to address the merits of that remittitor issue, the appellants also failed to properly object to the testimony, the evidence, and the closing arguments, which they now argue on appeal in an attempt to support a remittitor. And most of these arguments were never even raised below. Now, the verdict is not excessive, and that's based even on the appellant's own case law, including Schleider, Townsend, and Lorillard. In fact, in Schleider, the jury awarded $15 million in a 2014 verdict to the spouse of the decedent, who was a smoker and found comparatively liable for his own death. But the Schleider court affirmed the denial of the remittitor, finding the $15 million compared to the Townsend and Lorillard verdicts of $10 million was only a fraction more and not multiple times more. And thus it held it was reasonable.
And Ms. Tanaka, can I interrupt you? I want you to address some of the issues that we spoke with Ms. Gunn. She raised the issue about the verdict form. She raised the issue about the apportionment and your election, and what the judge said, that's fine. You don't need to be bound by that. Let's see if we could address some of the issues that concerned us that we addressed with Ms. Gunn, if we may.
Sure. I'll start with the set-off issue. And I know the set-off and the apportionment issues that Ms. Gunn raised, really, as she mentioned, from the appellant's perspective, go hand in hand. But in this case, the set-off issue has really no basis on, it doesn't matter whether the apportionment should or should not apply. And really, for the purposes of their motion for set-off, it doesn't matter what was presented at trial because the appellants failed to meet the statutory requirement to show what damages were actually settled. And so the appellant's motion for set-off was actually deficient and could never have been granted. This court in Anderson explained that the purpose of set-off is to prevent a party from recovering twice for the same damages. And in order to ensure that the set-off is applied to the same damages, the set-off statutes require a condition precedent. And that required the appellants to show the trial court a settlement release between the estate and the settling defendants for Mrs. Gage's wrongful death damages. But they didn't do that. Instead, they try to argue that all the same damages that were alleged against the appellants were also alleged against the settling defendants, which is true, but the only damages that were sought at trial and awarded by the jury were the wrongful death damages. The claims against the settling defendants also included Mr. Gage's personal injury claims, which included his non-economic damages for things like bodily injury, pain and suffering, disfigurement, loss of enjoyment of life, and his economic damages for things like medical bills and hospitalization. Now, the Reimer Court made clear that recovery for wrongful death cannot be set off by a settlement for personal injury claims. And this court's Ellison opinion from 2021 restated that settlement dollars are not synonymous with damages and could also include the value of avoiding trial, the risk and expense of trial. So by not meeting this statutory condition precedent, the appellants failed to show what the settlement was actually for. And as this court's Anderson opinion acknowledged, where this requirement is not met, any set-off would be mere speculation, which of course is insufficient to apply a set-off. So the apportionment issues and the other issues that the appellants argue in an attempt to support a set-off are really inapplicable. Now, there was nothing that prevented the appellants from seeking an order from the trial court compelling the settlement release for this purpose, but they chose not to do so. And even in their remittitor motion, the appellants only sought the amount of the settlement, which of course the dollar amount wouldn't resolve which damages were actually settled. And as this court's Anderson opinion established, this statutory condition precedent is required to be met at trial. And if it's not, there is no remedy on appeal, which is where we are now. While the appellants seek recourse from this court, it's too late. If it were allowed, it would render the statutory requirement meaningless. It would contradict this court's precedent in Anderson. It would encourage future defendants to ignore the statutory condition precedent and seek recourse on appeal for the first time. And it would also act as a delay tactic, which in this case prejudices Mrs. Gage, who's now in her 70s. So regardless of appellant's arguments as to whether setoff should or should not apply, their deficient motion could never have been granted, and thus they have been precluded from setoff. Therefore, this court should affirm the trial court's proper denial of the setoff. Now, with regards to the apportionment, it's really undisputed between the parties that apportionment doesn't apply to vicarious liability. And as to Burek Inc., Burek Inc. admitted it was vicariously liable for the driver EHOS. And the appellants actually agreed to have that admission read to the jury. They agreed to have the jury instructed that Burek Inc. was vicariously liable. And during post-trial motions and at the hearing, appellants agreed that Burek Inc. was liable for both John Burek and EHOS. They recognized that apportionment does not apply to vicarious liability, and in fact, asked the trial court to enter the appellant's own proposed or final judgment such that Burek Inc. and John Burek were vicariously liable, holding Burek Inc. entirely, jointly, and severally liable for the full $17 million compensatory award, plus, of course, its punitive award. So the apportionment doesn't apply because of vicarious liability, and we know that the jury found John Burek vicariously liable. Now, the appellants tried to argue that John Burek's vicarious liability should have never gone to the jury. And they do that, in doing that, they actually admit that they didn't do anything at trial to prevent the jury from deciding that issue. So in an attempt to skirt around that, they argue fundamental error, but the appellants waived that fundamental error argument when they affirmatively agreed to the jury instruction that directed the jury to decide the issue of whether John Burek was individually vicariously liable for EHOS. And they did that on numerous occasions. They agreed to the jury instructions before the opening statements. They agreed to the jury instructions after the close of evidence, and they agreed to the verdict form, all of which instructed the jury to decide the issue of John Burek's individual vicarious liability. Now, the Fifth DCA in the Morgan case cited this court's York v. State case from 2006 and clearly reiterated that fundamental error is waived where defense counsel affirmatively agrees to an improper instruction. Now, in the appellant's brief, they seem to try to argue that they're not claiming error with the jury instruction, but that contradicts their entire argument, where they state in their initial brief, quote, allowing the jury to determine that John Burek was individually vicariously liable for EHOS is fundamental error. And they again reiterate that in their reply brief. When they discuss this agency issue as to whether John Burek was individually vicariously liable for EHOS, they say, quote, should never have been submitted to the jury. But the appellants affirmatively asked the court to submit the issue to the jury when they affirmatively agreed to the jury instructions. And while it's the estate's position that that instruction wasn't erroneous, the appellant's arguments are based on the jury being, as they allege, improperly instructed. But that argument was waived when they affirmatively agreed to the instructions, and because fundamental error does not apply, the issue is not preserved for this court's consideration. So we have the appellants being vicariously liable, and it's undisputed that vicarious liability is not subject to apportionment. Now, the appellants do try to argue that because the jury was instructed or asked to apportion the gross compensatory award, that joint and several liability was waived, but that is contradicted by Florida law. The recent cases and the Thomas and Gore opinions make clear that the jury's apportionment is of no consequence to the gross amount of compensatory damages. If apportionment does not apply, it would be error for the court to apply apportionment regardless of whether the jury was asked to apportion the award. And here, the verdict form is clear. The jury was asked to award an amount of money that would compensate Mrs. Gage for the loss of her husband. The jury did that, and they awarded the gross amount of $17 million. The fact that they thereafter apportioned that is of no consequence. And so because the appellants are vicariously liable, apportionment can apply. Now, just to address the derivative argument, this court doesn't actually have to get there because it's undisputed that vicarious liability is not subject to apportionment. But as an academic discussion, the negligent entrustment claim, as Judge Kuzam pointed out, was an alternative theory of liability. And this claim falls squarely within the definition of derivative liability, a claim where both the derivative liable party and the directly liable tortfeasor commit a wrongful act, but there's no cause of action unless the directly liable tortfeasor commits that subsequent tort. Whereas here, the appellants negligently entrusted the truck to EHOS, but there would have been no cause of action had EHOS not driven that truck into Mr. Gage and killed him. Now, appellants try to argue this line of cases where negligent entrustment of a motor vehicle was subject to apportionment, but those cases don't apply here. And the reason is actually explained in the most recent of the appellant's cases, the Trevino case. And the Trevino court explained that the reason for the apportionment was based on the limitation of liability that was created by the enactment of Florida Statute 324.021, subsection 9B. And this limited the owner's liability such that the owner and the driver no longer shared the same liability. Thus, the negligent entrustment claim provided additional liability over that limitation, thereby requiring apportionment. However, as stated in the statute, this exception does not apply to commercial vehicles used in the course of business. And therefore, this line of cases that appellants rely upon are simply inapplicable. Here, there was no additional liability for the compensatory damages created by the negligent entrustment over the vicarious liability claim. The appellants were vicariously liable for all the harm that EHOS caused, which was Mr. Gage's death. And this was explained in one of the appellant's other cases, the Dunmore case, which explained that apportionment applies where a negligent entrustment claim imposed additional liability not available to the plaintiff against that party under any other alleged theory. That just doesn't apply here. There is no additional liability for compensatory damages that the negligent entrustment claim imposes, and thus apportionment doesn't apply. And this case just falls within the standard derivative liability claim as explained in Groveman. Now, appellants also rely on other cases like the Gedali's case and the Hennis case, but these cases, there's no discussion, no analysis, and they don't even address whether these claims were derivative or not, so they really are inapplicable. Instead, they address non-parties and whether non-parties should be placed on a verdict form as Fabre parties based on the issues in those cases, but they have no bearing on whether, and no analysis on whether those claims were derivative in nature. But as I stated, this court doesn't even need to get to this analysis because it's undisputed that apportionment doesn't apply to vicarious liability. And the appellants, both Burek Inc. admitted vicarious liability and John Burek was found vicariously liable in his individual capacity. And as mentioned, the appellants have lost the opportunity to challenge that, that verdict against John Burek, even though the record supports the same. So we would ask that this court affirm the final judgment as it is. I just wanted to go back just briefly. I know it really wasn't touched upon with regards to the remediator, but I wanted to point out that the remediator, while it's not excessive, the appellant's case law supports the size and the determination that the court made that the remediator should be denied. And the Schleider court, with their $15 million verdict from 2014, the Schleider court actually considered both Townsend and Lorillard, which the appellants rely upon. And finding that that $15 million was reasonable, the court, we can look at that even for today's standards. And that $15 million, when we consider inflation and the increase of the value of the dollar, would have actually been worth over $18.3 million last year when the jury awarded Mrs. Gage $17 million. Thus, even under the appellant's own case law, the size of the verdict was reasonable. But factually, the evidence of this case and the Gage's relationship and what Mrs. Gage lost far exceeds that of Schleider. Both cases were wrongful death cases where the surviving spouses were married to decedents for many years, but the Schleider decedent was disabled, unable to work, and was a smoker, and it was actually undisputed that he was partially at fault for his own death. Whereas here, Mr. Gage was healthy, he was walking for exercise on the day he was hit and killed, and he was providing Mrs. Gage extensive support, protection, and companionship right up until the day he died. The record demonstrates the type of extraordinary 46-year marriage that the Gages had, and their friends, family, and pastor explained their love and life was a remarkable symbiotic partnership, one which they needed each other. So when Mr. Gage died, Mrs. Gage was broken. She was suffered through the horrific trauma of Mr. Gage's sudden, unexpected, violent, and avoidable death without the opportunity to prepare or even say goodbye. The verdict was more than reasonable for Mrs. Gage's loss. The jury, of course, was given wide latitude to determine the verdict, which the correctness of the verdict was strengthened when the trial court denied the motion for remittiture. Now, appellants have failed to make any affirmative showing in the record that the jury was affected by passion or prejudice. Instead, the record shows that the jury was attentive, engaged, and had appropriate questions. Moreover, the basis for the appellant's request to remit the award to $2 million would actually be a reversal, because that's what the appellants themselves asked the jury to award in opening statements. So the trial court correctly denied the motion for remittiture, and we would ask this court to affirm the same. So for these reasons and those in our brief, we would ask this court to simply affirm the final judgment. And if there's no more questions, I'll rest with that. Thank you.
Thank you, counsel. I see no further questions at this time, and I will stop the clock here. Attorney Gunn, you have your remaining 5 minutes.
Thank you, Your Honor. I will begin where Ms. Tanaka began her remarks with the preservation question. And I'd like to address that as to all 4 issues that we've raised. The apportionment issue did not become an issue until after the trial. So obviously, we did not object to any of the verdict form or the apportionment or the active fault evidence at trial, because this was tried as an apportionment of active fault case. It was not until after the verdict, when the plaintiff got the benefit of all that, that they wanted the judgment to not reflect the apportionment. So it's our position there is no preservation problem as to that. The set-off issue was raised as it should have been raised after the trial in front of the trial court. This court in the Felgenhauer versus Bonds case made clear that set-off is not an issue that should be presented to the jury, and it was raised in an appropriate and timely manner in a motion after the verdict. The remittiture issue, we did file a motion for remittiture. Trial counsel filed it out of time, that's true, and was given permission to do that by the trial court. Plaintiffs have argued that the trial court did not have authority to do that because the trial court does not have authority to allow a motion for new trial out of time. But as we've explained in the brief, the trial court did have authority to allow a motion for remittiture out of time. And there's no argument that the trial court abused its discretion in finding that our trial lawyer had good cause and excusable neglect for that short amount of additional time. And then finally, as to the vicarious liability issue on the individual defendant, John Burek individually, we did bring that to the trial court's attention in a motion to alter or amend the judgment. It was not raised at all at trial. And so, you know, we have submitted to the court that it's fundamental error to apply a judgment on which there is no basis for liability, and that we do need to prove fundamental error because of the lack of preservation at trial on that, although it was presented to the trial court in a post-trial motion. The issue about whether—
Could you pause here for a moment? You know, this has been kind of, I'm not sure I have it crystallized. In the criminal law area, our Supreme Court has indicated that the conviction of an uncharged offense or a conviction for a total conviction where there can't be a crime may constitute fundamental error. In the civil, it doesn't appear there's much of a discussion about fundamental error in civil cases. Apparently, it's a very new concept getting fleshed out, but usually you're looking for some violation of a procedure like due process or a constitutional provision. My concern here is based on the present development of fundamental error in civil cases, what is it you are asking us to look to? What specific case or something at, that we are supposed to hang the fundamental error? Because as Justice Cardozo wrote years ago in The Nature of Judicial Process, we're not supposed to be like knights errant running around the field of battle.
Yes, Your Honor. We've cited for the court 2 cases in our brief on fundamental error, and I would refer to those: North Miami Hospital case versus Goldberg, which was a case in which the court, it's in a footnote, but it's there, said that it could be fundamental error to enter a judgment on a theory of liability that doesn't apply to that defendant. It was a products liability case, and there was a strict liability claim against someone that wasn't the seller. And so the court said, and it's our position that the same thing happened here, that you have a vicarious liability and agency claim against someone who can't be a principal, based on the Meyer case and on this court's case in Ilgen versus Henderson, which was likewise a franchisor case. That control is not enough, that you do have to have those first 2 elements, the acknowledgement by the principal and the agent's acceptance, kind of the contract part of agency. So North Miami versus Goldberg first, that entering a judgment against a defendant on a theory of liability that doesn't apply to them could be fundamental error. And then second, the Marks versus Del Castillo case, which said that it was fundamental error to enter a judgment for damages that are unrecoverable as a matter of law. That's all I was able to really find in the civil context. I was able to find as to the jury instruction issue, because that kind of got me a little bit about whether by not objecting to a jury instruction or by saying that something could be submitted to the jury, if you don't object to something at trial, obviously you're going to say the jury can decide it. And so that just can't be inconsistent with fundamental error to say, yes, the jury was instructed on this. We are not arguing an error in the instruction itself. We are arguing that it was an error to submit the issue to the jury at all. And what I was able to find for the court on that really is just what Judge Padovano wrote about it, which is just because you
Good news, as I've read that.
Okay, awesome.
I found out what Phil wrote about it. I've read it and I photocopied it. We're okay.
Okay, great. And, normally I'd rather have a case, but if Judge Padovano is writing it, we all know what that means. But so that's what we would rely on for the fundamental error issue.
Thank you. I'll let you get back to the remainder of your argument.
Okay, thank you, Your Honor. As to the remitter issue, we do have kind of a threshold legal issue that we would ask the court to focus on, and that is whether it's appropriate for the trial court or this court to be looking at other trial court verdicts as opposed to limiting your analysis to reported decisions that have approved a verdict. It's our position, and the 11th Circuit has explained this in quite a bit of detail in the Bravo versus United States case, that the analysis of what is the trend and what's an okay verdict should really be limited to reported decisions. And I realize that counsel today has limited her argument to reported decisions, but at the trial court and in their brief, they relied a lot on untested jury verdicts. And as the court in Bravo explained, those are kind of these ghosts that are out there that haven't been really challenged or approved. And we should be limiting our analysis to those verdicts that have been challenged and approved on appeal in determining what's appropriate. And the case is, although these awards in numbers and gross numbers seem like kind of in the range of what this verdict was, and make no mistake, it's a terrible, horrible case. And this surviving spouse suffered an incredible loss. The plaintiffs have not pointed to any case where any reported appellate decision approving an award over the number of years that we have in this case. So yes, we have cases where there was a similar gross amount, but that was intended to compensate the survivor for a much greater number of years. And also there was an issue about the decedent having a period of time of pain and suffering in those cases, which again is an issue as to the set-off. The argument was that here, the damages paid by the settling franchisor defendants are somehow different than the damages against which the jury verdict is meant to be entered against the remaining defendants. We don't have to guess in this case. The plaintiff's complaint is really, really clear. They sued every defendant in the same paragraphs, in the same counts, for the same damages and the same theories of liability. This is not a case where the decedent survived for a period of time, had his own injury claim, and then separately a wrongful death claim. So it's not that situation. And again, we have the Felgenhauer versus Bonds case from this court establishing that it would not have been appropriate to try to prove the set-off entitlement at trial. The issue about whether vicarious liability can coexist with apportionment, I think that happened in the Wells case, it happened in the Grobman case, and it really comes down to vicarious liability for what? If Burrick Inc. or John Burrick are vicariously liable for the driver, is that vicarious liability for 100% or vicarious liability for 40%? And that's where the apportionment comes in. And that's why the apportionment matters. Because if we throw out the apportionment, now we've created 100% vicarious liability, but it really should be vicarious liability for what the driver's liability is. And that should be limited to his percentage of fault.
That was the expiration of your time.
Yeah, thank you, Your Honor. We would ask the court to reverse.
Thank you. Thank you both.
Thank you both.
And we will appreciate your arguments and allow you to, what do they call it, segue back, use the light fantastic, whatever the technological word it is that I